Oh, yes, we are recording, so please hit got it if you give permission. All right, as everyone knows from our emails that we sent out through our listserv, today we have a guest speaker who is being joined by a colleague of hers as well. But the guest speaker that we have listed here on the agenda is Lisa Wade, who's a nurse and a legal nurse consultant with Wade Nurse Consultants, as you see. Her topic today will focus on what we call defense medical examinations, which, as we know, the insurance industry likes to call independent medical examinations. You see, Lisa has a very impressive background, a graduate of Villanova University School of Nursing. She's a registered nurse and she founded her own company here. Lisa has a wide range of experience in patient care and other healthcare settings. And currently, she provides legal nurse consulting services. We're using Lisa to help with medical record review and organization. She does that very well, and she does a lot of other things very well. But I thought it'd be helpful to hear her perspectives about defense medical examinations. So that's going to be her focus today. And her colleague's name is it Tim Kane? Did I get that correct?
Yes.
Okay, Tim Kane is with us as well. All right, Jen, you can take that down, and we'll turn it over to Lisa or Tim to begin. And if you have any materials to share, I take it that you'll put them up on the screen.
Absolutely. How about right now?
Now's as good a time as ever. Okay, thank you,
Excellent.
Lisa. You can take it from here.
Well, thank you for inviting us here today. And we're going to give you all of the tips, defense medical exams, all the tips to help you prepare your injured clients to attend these events. And also to make sure you get your CLE credit. I do have code words prepared. And get your pen and paper down or note taker and get ready for when I do that, probably mid presentation and towards the end, so you can get that CLE credit that we know that you need. So uh, if you also get ready to get any questions, you can start jotting them down now. So towards the end, we will let you know when to rattle off those questions. All right. Uh, as Mark said, I am Lisa Wade. I am founder of Wade Nurse Consultants. I do legal nurse consulting. I am a graduate of Villanova University. Go Wildcats. And I am a very experienced nurse, almost 40 years worth of experience. And I have been using the last 7 as a legal nurse consultant, assisting attorneys like yourself with reviewing medical records, as well as attending DMEs as an observer. I am also a podcast host. So if you head over to YouTube and you view my channel, Lisa Wade LNC, you will see my podcast called Should You Take That Case, where the last about 2 years or a little more, I've been interviewing attorneys like yourselves. You get a chance to have a little exposure and a chance to talk about medical records, which I love to talk about, and how you decide on the cases that you choose, which cases are good cases to take, which cases are not so good, why you refer them out. I'd love to have any of you on my show. So come on over and send me a message through my YouTube channel, Lisa Wade LNC. But I also have a co-host, a co-presenter today, Tim Kane, who is a legal nurse consultant like myself with much experience attending DMEs in the New York and surrounding areas. And I'm going to bring out Tim. Tim, introduce yourself.
Hello. Yes, I'm actually up in Buffalo, New York, but I've been attending DMEs since 2012. I have DME clients all over the state, including New York City and Long Island. I've attended probably over 1,200 DMEs, but my home base is in Buffalo, and I graduate of Trocaire College. Unlike Lisa, it's not a Division I basketball school, but I'm also, a fan of the Villanova Wildcats basketball team. But enough said about that. So that's my history. DMEs are pretty much my home base, and I've attended neuro DMEs, neuropsych DMEs, orthopedic, and chiropractic, amongst many others.
All right, Tim, let me just scooch over. I'm gonna just bring up our topic again so everybody remembers. Getting ready to help you prepare your injured clients. We know that DME process can be stressful for them. It could be anxiety producing, and we hopefully will let you have some ways to get them more confident, more calm, and more prepared to attend these events. And these are some of the topics we're going to go over: IME versus DMEs, answering your clients' questions, because I am going to be the stand-in for your injured client today. I'm going to ask all of the questions that I know are on their mind, the things that make them nervous, the things that make them anxious, and I'm going to be your client today. I'm going to ask those questions, and Tim and I are going to get those answers to you. We'll talk about paperwork, mechanisms of injury, and DME nurse observers. So go, Tim. Tell us a little bit about that IME versus DME.
All right. Well, thank you. Like Mark kind of said before we hopped on, all my attorney clients will never really condone the IME term. The official term in New York State and all other states is independent medical exam, but no plaintiff attorney is going to tell you that they're really independent, because they're not. And so the plaintiff attorneys over the years have termed them defense medical exams, because that's really who they benefit. That exam is a doctor hired by that defense who makes huge money, and they just want to downplay your client's injuries and reduce their cause and meeting. So the real term is DME, but you will see IME. I even was at an IME trial one time, and a doc that I saw an IME on, he admitted that he has made over 7 figures just attending IMEs. So those docs are proactive with the insurance company and do what they can to make that company happy to keep writing and sending them checks to them.
Yeah, it's these hired guns. That is what some of my attorney clients have called them. People that are physicians that are set up to just do repeat business, and sometimes they say the similar things from one client to the next, or that how long or how often they show up in court, and how much of their income comes from these exams. So, and someone asked if we can get copies of the PowerPoint slides, and I think that'll be fine. I think
That'd
we'll
be easy.
able to do that for you.
Yeah.
Perfect. We're going to get into some of the questions that these clients of yours may have, and during that time, let's get some discussion in here about how you can prepare for them.
A lot. I'm sorry. Oh, I was just gonna say that a lot of times, a lot of plaintiff attorney clients of mine will have me talk to their client the day before, and I'll answer most of these questions.
Yeah, and that happens to me too. And I think it also helps to have somebody to talk to, helps get them ready for this scenario, and also getting there when they should. So the first question is, why do I have to attend this examination? Tim.
I get this question from patients. I'm a nurse. It's hard to not call them patients, even though they're clients, they're injured. But to me, they'll always be patients. And yes, and that's where I start out with, like, what I've already said, the IME versus DME speech, that they need to realize that the defense has a right to have their doctor examine you, and we're going to go to this exam, and that doc is going to provide their side with an opinion about your injuries, about your situation, and the defense's goal is for that doctor to reduce or make them less significant to what they really are. So that's why they have to attend the exam. They're even court ordered. I get a copy of a court order signed from the court outside of Buffalo here, or Syracuse, or Albany, directing that client to attend, and that makes them concerned. But so that's my reason why I tell them why they have to tell the exam or attend it.
Well, and some are so concerned because may have been through a lot of doctor's appointments and examinations, and they're wondering, why the heck do I have to go to this? Is this the same kind of appointment like my doctor's appointment?
That is absolutely correct. Is they feel that this injury has changed their life, and all they do is go to appointments, and this is just another one. But the other aspect I get why they have to attend it, then when I tell them that, then they feel that they're afraid they're going to be taken advantage of. And I just tell them that's why you have a great attorney hired, and you'll have someone with you to be an observer and write a report. But that is a major concern, is they feel that it's going to be another deposition, and it's really not supposed to be one.
Mm-hmm. All right, Tim, that's good. Next question is, how long is this exam? How long will it take?
That can really vary. A typical orthopedic, neurological, shoulder surgeon will go anywhere, usually average 40 to 45 minutes. I attend for plaintiff injury clients, neuropsychology exams. Those are people that have head injuries. And these clients get sent to these neuropsych exams that can go 6 to 8 hours, and sometimes they go in 2 and 3 days. So my point is it really varies on the injury, but a standard neck and back neurosurgeon exam is probably 35 to 40 minutes.
And that's got to give them some comfort to know exactly how long they may have to be there. I think that prepares them for what is to come. And also, I think I know we said how long it's going to take, but how about where do they have to go? How, what time do I have to be there? Those kinds of questions come
They'll
up.
receive an IME notice, and there's a couple different spots. Some of these docs do them in their own office, but some of these docs get flown in from all over the country to attend these exams for whoever's hired them. And then there's actual IME centers outside of Buffalo and Syracuse that it's these docs sitting in these offices, and they're doing independent medical exams all day. So that's where I believe the laws state, though, that the exam has to be in a certain radius of where the client lives. So they can't be really asked to travel far for that. So that's where they'll be.
Mm-hmm. Well, the timing, I often talk to people about the timing of the appointments, and I check with them the night before just to make sure we're going to be at the right place at the right time together. So, because, and here comes your first code word, don't be late. I tell them not to be late for these appointments, because terrible things can happen because of
Not
that
only
telehealth.
don't be late, they have to attend, and if they don't attend, they're considered a no-show. And the doc will send a no-show fee that the plaintiff is responsible for paying. And it's my understanding, my attorney clients in New York have told me that if a client no-shows, the defense has the opportunity, I'm not an attorney, this is just words I'm hearing, has the opportunity to file for dismissal, but then a lot of times they're allowed another chance. But a client skipping a DME can be detrimental to a case. And not only skipping it, they really can't be late. They'll give them those IME centers. They've got people stacked in the waiting room. They'll give them 10 minutes, then they'll say, we're moving on and this is canceled. So yes, don't be late.
Mhm. And the next question, who will be performing this examination, Tim?
Those are a variety of docs. It always seems to be the guys at the end of their career. It's the guys that have, or ladies that have had 20, 30 years in as an MD or an orthopedic surgeon. And they're the ones that are ending their career out, becoming an IME doc. It's the orthopedic surgeons, it's the neurologists, it's the neuropsych psychologists who aren't even real, they're not medical doctors at all, but they're the ones doing the neuropsychs. I go to a lot of chiropractic exams for no faults as well. So they're the ones that are performing it.
Right. And next, what should I expect to happen during this exam? What's going to go on?
In my opinion, this is a real important part. If an attorney is prepping their client, there's a lot of things that are going to happen in the exam. These exams are basically history and physicals. They're not much difference from a doctor's appointment, but they're not a doctor's appointment. That doctor does not treat them. He will offer no advice on their injuries, and he'll only give that opinion to the insurance company. But here's what will happen. During the history, attorneys got to decide if they want their client to answer questions about the accident, or they don't want them answering questions about the accident at all. And if they do allow any questions on the accident, they should stick to the mechanism of injury. And I believe we're going to get to that in a little while.
Mhm. Oh, so that history part. Sometimes when I go in, some of these physicians, they already have a history written down in front of them of your client's injuries. Sometimes I find that they are just rattling off that list that they have, and they're not really asking questions about history or what went on with them, like would happen at a regular doctor's appointment. So sometimes these clients are really trying to uh, explain everything that has gone on with them to these physicians, and the physicians are comparing and contrasting whether what they're saying at that appointment is what they said 3 months ago or 6 months ago. And that is frustrating for some people that come in, for sure.
A lot of these IMEs that I attend, these docs already they come after the depositions, and the docs have the depositions in already a copy, and they're reading that, and they will sometimes take details from the deposition and they'll just read it aloud and just kind of note it in that history. Yes, but they're very prepared with all the medical records and everything prior in the
Right. And
history.
you've said it before, Tim. You let these physicians are not their friends.
And they try to make it that way. They'll be very professional. They'll be very, calm and social. But in the bottom line, they're not your friend. No, not at all.
Right, let's see what questions we have next. We did say, where and when will this exam take place? I know we talked a little bit about that so far, but sometimes I find some of these appointments are places that are pretty far away. Sometimes I've had someone that had to travel 2.5 hours to get to a workers' comp appointment, and I can see that could be a frustrating event, definitely. So you mentioned there's sometimes these processing centers that people just get funneled into. So tell us a little bit about where and when these exams take place.
I mentioned that they're supposed to take place within a certain radius of the client's home. A lot of times these places are, these exams are years later and people move away. I've had IME clients have to fly back to Buffalo or New York or Syracuse because they had an accident 3 years ago and then they moved to Colorado. Sometimes accommodations are attempted to be made for them in their new state, and sometimes they're not. And a lot of times the defense will compensate their travel expenses. But yes, the IME centers are all over the country, I believe. Well, at least they're all over New York and in New York City. And a majority of the people that are in that center are within that radius. But a lot of times these docs, like I know an orthopedic surgeon who does IMEs in Buffalo, Syracuse, and he goes all the way down to Long Island. He's happy to drive because the money's huge.
Oh, and the distance can be troublesome. So sometimes people have a concern about how are they going to get to this appointment? How do they make it there? Because some of these physicians, that's the first question they ask when they come through the door. How did you get here today? Did you drive yourself?
And a lot of times there's an ulterior motive to that because they will ask that question because the person's saying they have X amount of injuries, and if they're even driving, the doc will say that, well, then if they're able to drive, they're not as bad as they say they are. But I often tell clients in the prior that if you get that question or ask them their driving status, and this is the truth, 99% of these people say, my husband drives me all the time. And if I drive minimally when I absolutely have to, or short distances because of the result of the accident. That is said in many of my IMEs.
Yeah, well, and sometimes, there's no other way to get there. Maybe their spouse doesn't drive. There's literally no other way that they can get there because of the distance and the time. And
Some of the
having help.
some of the larger firms that I know of will actually provide transportation. That doesn't happen very often, but I have seen that.
All right. Well, next question. Tim, what should I sign or complete any paperwork while I am at this exam?
We are getting to the two parts of this presentation that I feel personally are the most important. I have attorney clients that tell me to decline any paperwork that the doc wants them to fill out. A lot of times, the doctor will have them fill out 4 and 5 pages, and that's where they'll make their report from, and not a real thorough examination. The other thing too, they just don't want their client writing anything down, because then I guess that's just, hard to dispute once it's on paper. They're allowed to ask the questions that are on that paper, but my attorney clients do not want people filling any paperwork out. So that's something an attorney has to decide. I do have some other attorney clients that don't have a big issue with it, but I have a lot that do.
And the same thing, it's a mixed bag for me, especially pain assessments. There could be pain assessment forms, mobility assessment forms that, like you would fill out a form when you went to the doctor or the physical therapist. So people may be inclined to, just complete paperwork when they walk in the door because they feel like they're at a normal doctor's appointment.
And the other fear with the paperwork that attorneys have is that client could say something that is opposite of what they've said in the past, and they didn't even mean it, or it's another crack at the apple of anything that they've already said. So they don't want to give the defense that opportunity.
I got you. All right, next, what should I say or avoid saying during this examination, Tim?
This is this is the biggest part of the exam, and this is such an important part. When it comes to the details of the exam, I have attorneys that tell their client, I don't even have to tell them, it's discussed prior, that once the doc asks about the exam, that they tell the doc any questions about the accident, any questions about the accident are to be directed to their attorney. These IME doctors can't stand that, but they have to take it. My other attorney clients want their client to stick to the mechanism of injury. They will answer, I'm going to give you a hypothetical situation. Mrs. Smith, she was at a red light. She was T-boned by another vehicle. She hit her head on the steering wheel and her shoulder against the door. That's the details of the accident. If the doc, I'll intervene often if the doc asks, well, were you stopped? Are you sure you were stopped? How fast do you think the other car was going? What color was your light? I mean, were there kids in the car? If the questions are non-medically related, the plaintiff attorneys in my business tell me that those questions have to stick with medical issues. So that's an important part that the attorney-client can prep their client, because they don't want another deposition occurring in that exam.
All right. And I've had some clients or been on some visits where injured clients called their attorneys while they were there because something came up that they weren't prepared for, and they wanted to know, what should they do? What should they say? Should I leave? But I've also been called in to attend some of these events because sometimes people maybe don't want to be represented or thought of as uncooperative or non-compliant, and they've had some problems in the past. So they just have me come along to be a bystanding observer. So yeah, watching what they say and wanted to know if, if something comes up, should I call you or not call you?
That's just it. I mean, as you're there and I'm there, we're there as fair game. We have no interest in the outcome. So our opinions and our, what we say that occurred are very credible, because it doesn't matter to us how this case, turns out. So yes, and I've been with clients a couple times. We've had to call attorneys once or twice. They won't allow me back there. They always do in the end. And, in the beginning, I used to call attorneys and they would say, give me some instructions. But yeah, they can be difficult at times.
All right. And the last and most important question, who will be accompanying me to this examination?
That's a great question, because like I said, I've attended over at least 1,200. I've been doing at this since 2012, and I love looking at waiting rooms. A lot of people are alone. Some have attorneys with them, some have paralegals with them, some have other nurses with them. But the main point of or the perk of having an observer is to get your medical eyes and ears of what occurred in that exam. A nurse observer is your best person, but that will give you a blow-by-blow account, what happened in the exam, what was said, how the doctor's demeanor was, and be able to dispute anything that he says occurred or didn't occur.
Mm-hmm. Well, sometimes, like you said, paralegals or legal assistants do go with clients to these events. And what is your take on
The thing about
non-medical people?
on paralegals, and I've spoke to them, they do attend them. They'll tell me they don't want to. They do because their boss tells them, and that's a non-independent observer, because that paralegal is going to want that case to end well for their boss. Attorneys will go, which I'm not an attorney, but I always wonder about that, because it's my understanding that if an exam wants to be disputed, an attorney can't be a witness for something that they're involved in with their client. So they have nobody to call or to dispute the exam if they're the witness, where if they have a nurse observer, there's a tool to utilize in disputing the exam's contents.
And I have heard that from a few of my attorney clients. And here comes your next code words. You can't be your own DME rebuttal witness. If you are the attorney, if there is some kind of discrepancy or dispute about what that physician did or didn't do or said or didn't say at this DME, you can't put yourself on the witness stand to rebut any of those statements. So that's the word on the street. That's what I've heard. What have you heard, Tim?
Me as well. If they attend the exam, wonderful. Their client loves that, but their hands are tied if anything comes out of it.
Well, that's why I say having a nurse observer, like you said, we are more independent. We are just observing the facts of what's happened. You called us fact finders before, Tim.
I've been referred to as a fact witness as a nurse at these exams. Yes.
All right. Well, I think we are at the section, time for comments and questions or anything else that you have for us. It's been wonderful. Tell us what you want to know.
All right, well, I have a question. Tim, you said that if the doctor does something inappropriate, such as getting into the liability issues as opposed to the injury, how the accident occurred, et cetera, you will intervene.
Correct.
And what do you do if a doctor says to you, well, you're here to observe, you can't speak, you're not an attorney, you can't object, you have no input. What do you do?
I've had that happen a couple of times, and that's why I like to use when I describe this, I like to use my word intervene, because they'll say you can't interfere with my exam. And my answer to that is I'm not interfering. Here's my common response. Dr. Jones, Mrs. Smith has an attorney that has instructed me to make sure that you keep the questions on a medical nature. And these questions don't really qualify for that. If we could just keep the questions on a medical nature and move on, we would both appreciate that. Sometimes I get a little glare, and sometimes I'll get that response, but then I'll just sit quietly, and then he'll move on to a medical, question. I've never been thrown out. I've never been, it just sets the tone that I'm here to make sure you keep this on the up and up. I could even give you a scenario, and I told him no to this, and he didn't fight with me about this. You know how there's exam tables and they have paper on them. He asked the client to draw a diagram of the accident on the exam paper. And I said, we can't do that. The attorney's not going to allow that. And they're going to want me, I need to tell you that we're not going to allow that. And the guy said, okay.
Yes,
I think they just try everything and then they just see what sticks.
That's not a normal part of a history and physical exam.
Not at all. And I only had that happen once. And that was a neurosurgeon who was pretty successful over the years. But yeah, I told him no, and he just moved on.
Thank you.
Yeah, I have a couple of questions. First, thank you for the presentation, Lisa and Tim. Appreciate it. I've been going to medical exams, defense medicals, for a good part of my 30-year career. And I often, was concerned about me being involved if there was a dispute. Like you said, you don't want to be a witness. And so when I could, I'd try to send somebody. But the question I have for that is kind of how you answer that if you're called as a witness, because even though you're a fact observer, you are hired by the plaintiff's attorney, just like the doctor's hired by the defense. So when they get you on the stand and try to present that as if you may be somewhat biased, how do you respond to that to show that you're really not?
Well, there's a couple of things there. To say that we're not biased is, I just would have to reiterate that I'm there for I've actually, in some of these exams, and plaintiff attorneys, I don't know if this will answer your question, have appreciated this because they'll get their doctor's report and the doc will say something about what happened in the report, and the attorney will come to me, and the patient that is saying is the doc is lying, I'll say, no, my notes match that. So my point is that's the other objection, or the other objective of sending us. But on the bias, I mean, we're making a minimum amount of money that comes to us regardless of the outcome. And to call me biased is, I would just have to answer that I'm not, because the end result in the end game of this exam and what happens in the exam doesn't affect my business like it does these docs.
So as far as your notes, I assume that if we hire you to go to the medical, you provide the notes to us, right?
Correct. I provide a complete narrative, and it's a history and physical of the whole. These are history and physicals. It's the whole exam from start to finish. I have other attorneys I fill out affidavits for, Because in the medical world, this is really no big deal. And you've attended many of these, so you know what I'm going to talk about, or you'll know what I mean. When they do these ranges of motion, a lot of docs will use a goniometer or an inclinometer. At least the proper medical examination for that is to take your range of motion numbers from that. A lot of these docs will just eyeball that. I get requests from attorneys to sign an affidavit stating that, and that's their intention is to bring me in to dispute the doc's findings on the range of motion. Is how could he do that if he didn't have a tool? No.
Yeah, see that a lot.
Yeah.
Another question is, I do work in New Jersey. I'm not sure if you guys handle any medicals, defense medicals over there, but it often becomes a problem because unlike Pennsylvania, there is no rule that says an attorney or observer is permitted. In some courts, different counties, they'll let you do it, but very strict on what you can say or do in there. And so what about something like that, Lisa? Maybe you handle things in New Jersey. Is that something you do?
I have had cases, most of my DMEs have been in the Pennsylvania area, but New Jersey definitely is in there. And it's all settled when I get there. How it got settled, I don't know. But it's already decided since once they've asked me to come to New Jersey. So how that happened, I can't give you that.
I have something to add to that. I am an admin in Facebook about 3,000 legal nurses, and I know a lot from Jersey, and they're telling me that it's gone back and forth with New Jersey regulations about observers. And I'm hearing recently that New Jersey is now back allowing observers for, there was a little time that they didn't, and the information, my source, that's only probably a month ago that I heard that there's that observers are in New Jersey again, if that helps.
Yeah.
The last 3 I did was in New Jersey.
A lot of times we'll get an agreement up front, but when I go, I usually don't like to discuss it. I'll just show up with the client and take the position that she or he has a right and wants me there. And if the doctor has a real problem with it, we'll call defense counsel. Sometimes we'll just leave. But Pennsylvania, it's pretty clear cut. I have one. So how about federal court? Any dealings there?
I've never had to go to federal court for any of this. I would love to.
Not yet.
No.
I'm open, but it just
I would
hasn't
love
come
to.
up.
It's the
Yeah,
same
no,
kind of, proceeding. They have a right to a defense medical, and I don't think there's any real set rule on whether lawyers can go. Maybe some of the other folks on the meeting here know about that, but usually approach it the same way and go or send somebody. Usually don't have a problem. So thanks for your time.
Sure. And I don't know if this helps. The other thing in New York and its case law, my reports are considered attorney-client privilege, and they can't be turned over, to the other side. I don't know how other states go, but I just find that interesting for me in New York.
Tim, on
That is
that note, does that mean that you are not, I just want to get clear on what you meant by that. If it becomes necessary or helpful to our side to turn that report over, in other words, if we get the DME report and we pick up on discrepancies comparing it to your report, we would likely have to turn that over, although it would be considered impeachment. I think most judges would say we would have to produce your report if we're going to call you as a rebuttal witness.
It's just my understanding that they don't have a right to my report, where like the doc has to turn his over to you.
Oh,
Yeah.
I see what you're saying.
Like
Yeah.
I'm there as your agent.
Right.
Yeah.
Right. So you said earlier you consider yourself a fact witness. You're not a medical expert.
Right.
The report you generate is not a treating physician's medical expert report or a medical expert who's hired for the purpose of litigation. You're there as a fact witness.
I don't have the
Yeah.
education to dispute his opinion, but I could dispute what he said occurred or didn't occur. Because sometimes, you would hear stories of these people going to these IMEs alone, see the doc for 2 minutes, and he makes a 15-page report on everything. And they think that's all baloney.
So Tim, you prepare and Lisa, when you attend, you prepare a contemporaneous report and give it to the attorney that who hires you, right?
Correct.
Absolutely.
You don't wait to see the defense medical report, right?
No.
Okay.
No, oftentimes I would like to see the defense medical report more, but I only see it if there's an issue. They'll send it to me if they're thinking about doing something on it, but if they don't, I never see
Yeah.
it. Yeah.
Yeah, what I've done in the past where I've hired nurses to attend who do contemporaneous reports, and I see a discrepancy between the nurse's report and the DME report. I ask the nurse whom I've hired to prepare a second report that compares and contrasts the two, that points out the discrepancies. And I find that very useful.
Oh, well, that's happened. And actually it hasn't been happened very often, but it's after I've turned in my report and then they get the DME report. If they have a question or a concern, I, you know, I can generate an addendum to that report.
Right, right.
And I'm often asked to do an affidavit to set anything in particular after my report's in. Yeah.
Mhm. How does your firm charge, Lisa, for attendance at DMEs and for that initial report? Attendance plus the initial report.
Uh, the only thing is I try and do a flat fee, but I take into account everything that is going on. If there's a specific distance that we have to travel that is out of the ordinary, I'll just include that in a flat rate and present it to you as an estimate, and you let me know how that works for you.
Okay,
And that'll, again, the flat fee that I generate, estimate, it'll include that report, that travel time, everything.
okay. So I hesitate to put you on the spot, and please tell me that you don't have this information handy, but let's assume it's a typical orthopedic surgeon, defense medical that's going to be done within, an hour amount of time. And, you have an hour travel time, it's a half hour away back and forth. So how roughly what would that be, including the initial report?
Well, if I'm in, Kenwood is a big place for these reviews, which is not very far from me. And I'll say roughly we'll start at 4 to 4:50 for that event if it's going to take an hour.
Okay. And that would include the initial report, right?
Absolutely.
Okay. And when you do your initial report, do you try to capture verbatim the questions and answers during the history part? You do a
No,
recording?
it's not a stenographer kind of thing. And I don't always do recordings because some people have told me, no, don't record. They told me that before I've gotten there, but sometimes I do. I'll just have the recorder run, but mostly it is decided already before I get there. It is just mostly in Pennsylvania. They
Yeah.
tell me yes or no. Mostly no. And but
And
yeah.
you mean the attorney hiring you tells you
Yeah.
one way or the other?
Yeah.
Because
Yeah,
there is a right to record under the Pennsylvania state rule. We have the right to record if we choose that.
yeah.
If
So-
the doctor resists, too bad. The rule's very clear that we can audio record it.
I do it in New York. And I'm kind of just quiet about it. And I've talked to partners in New York, and they're like, yeah, don't worry about it. It's my understanding, like, again, if I'm saying it right, it's a one person, as long as one person in the room knows there's a recording going, I guess I'm not going to jail, but a lot of times, yeah, I will audio record. I don't even bring it up. It's in my pocket, and it just runs. And my attorney clients will say, yeah, we'll never, in New York, they'll never ask me for it. They'll say that's just to help you with your notes. But
Yeah.
and to answer your other question, I won't do like a stenographer. Like, say, the doc says, okay, Mrs. Jones, what treatments have you had? I'll say Mrs. Jones answered her treatments are the following, you know, something like that.
Right.
Yeah.
Pennsylvania is a two-party consent state,
Yeah,
so
we're one.
you have to get, in Pennsylvania, you have to get both
Right,
sides consent. So what we would typically do if we choose to record is we would, as the law, what our law firm does is we let the opposing attorney know that up front, that, you know, we'll have someone there and that person will be audio recording,
right.
you know, so just to avoid any
Any trouble?
issue along those lines.
I've had no issue with how my policy, how I've done that for almost 12 years now. It's never been an issue.
Mm,
Well, whether I record or not, you know, what I always do is when I am done, I make my own recording in the parking lot in the car. And you know, we've seen histories and physicals, you know, thousands of them. So I know exactly how a history and physical is supposed to go. And anything that varies from that stands out in my mind. And generally, I just make my own recording of myself and what I've witnessed as soon as I leave.
yeah, that's a good idea. I'm curious among our members here, what's the, how do you react to that? Excuse me, it's always brought up on the spot. It's never, you know, the opposing attorney never asks us ahead of time, but I've had plenty of situations where I get a call from either my client or the nurse who's attending saying, Dr. X is insisting that I, the client, fill out paperwork. What do I do? Of course, I prep the client ahead of time, don't fill out paperwork, you know? But what's everyone's view about that? If, let's say it's like Lisa mentioned, pain, you know, what a treating physician might typically have the new client fill out a pain form, you know, that type of thing.
Yeah, Mark, that's a good point. And I have just a general rule of not filling out any forms. Like Tim was saying, you get some lawyers just say flat out, don't do it. And usually we'll cite to the rule, and the rule doesn't say that you have to, you know, complete any forms. It's an examination, not a questionnaire session, you know, to fill out forms. And like Tim also mentioned, I guess one of the concerns is it's another piece of paper, a document where your client has filled information out and maybe it doesn't quite match up with exactly what's in the DEP or the interrogatories or some other document. So it gives them another opportunity to, you know, pick apart or try to show some consistency. I've never, you know, been in a position where I've said, yeah, fill out the form.
Yeah.
I don't.
Yeah, I agree with Mike. I pretty much follow that. It's Frank Baldo. I don't know why I'm not on the screen, but no, it's another, like you said, it's another bite at the apple that I don't think they're entitled to.
Any other thoughts on that? From any attorneys? Jen,
Agree.
any thoughts, Jen?
Not on my end, no.
Okay.
I have
Yeah, I think
another
that- I
question.
think that's-
Mark, if I have
Uh,
another question, if I can,
Sure.
unrelated to that topic. I'm having a hard time getting my head around the concept that Tim, for example, would be there as an independent observer, disinterested in the result, not as and as a fact witness only, and his report not being discoverable.
That what information what gives me that is that what's what my attorney clients tell me is they say we prefer you because you're independent, you don't have a hand in the game. You know, yeah, yes, I am an agent of theirs, but there's it's the outcome that I don't have the interest in, which I believe is why they tell me that puts me in a better position than somebody from their firm. I'm not an employee of the firm. I'm a hired outside contractor.
But it's more that you're a fact witness, not an expert.
Correct.
Yeah, I
Yeah.
think, Bob, from my perspective, I think it depends on the the discovery request the defense has made, you know, assuming we're in Pennsylvania state court, you know, there's no self-executing discovery,
Mhm.
unlike in federal court. But I think it would depend upon the nature, the requests that have been made. I I usually don't, I mean, what I typically receive from the defense, you know, are the standard interrogatories, request production documents, and
Mhm.
expert interrogatories. And almost always, I can't remember a time where I concluded that any of these interrogatories or requests would require me to produce the nurse's report. Practically speaking, though, the way I look at it is once I get the defense medical report, compare it to the nurse's report, whom I've hired. If it's consistent, there's nothing there that evidences, you know, a significant contradiction, or then I really don't care about producing my nurse's report because it doesn't add anything. But if there is a contradiction, then I take the next step and have the nurse prepare a second report that points out the inconsistencies. And then I produce both those reports because I want to then use that for rebuttal. And I don't want to take a chance that a judge is going to say, oh, you should have, you know, you should have produced these reports, even though in theory, as we know,
Of course.
rebuttal's rebuttal. But by that time, I think a judge is going to say, well, you knew you were going to call this witness. It's unfair
Mhm.
that you didn't produce these two reports. So that's how I practically go about it.
I do affidavits often on if there's discrepancies. I rarely get pulled into a courtroom, if at all, but I get that request and I come into the attorney's office and just, you know, sign it and look at it and go from there.
Well, thank you.
Yeah,
It
Mark,
sounds like
I
in New
agree with
York that
you.
the affidavit would be produced, right? Or that your expectation, Tim, is if you get to the point of doing an affidavit in New York, the lawyer that hires you will give that to the opposing lawyer, right?
That's what he tells me. He says, I'm going to use this in negotiations to say, I have you willing to say this. And I'm hoping that once they see what you're willing to say, I'll get a number out of them and we won't put a trial.
Yeah.
Yeah.
Oh, if it were
And
that easy.
let me
Sounds
just
like
say,
it's easier in New York than it is here in Pennsylvania.
Yeah.
I
Mike,
have
you
not
about to
had
say
as many affidavits or as Tim has had, because in general, my visits go well. I think I think physicians are more amenable to being, I suppose, on their best behavior when I'm there, and I've had a couple of extreme cases or extreme issues or problems. Um,
That's the
physician's
biggest part.
language or whatever,
Yeah.
but not a lot.
Yeah. Yeah, I think that part of the value of hiring you to be there is the deterrent effect. You know, it really, when that physician knows there's a nurse there who knows the medicine and knows the routine, I think that presents a huge deterrent effect to that physician. I would never ever, I mean, for years I've always had a nurse attend with my client.
Sure.
I've never attended one in my life. Never. I've always had a nurse attend.
You save yourself a lot of aggravation. It's
Yeah.
often not a pleasant, it's confrontational. I mean, that's my experience, but I got started going to these things as a young lawyer for, you know, other lawyers in the firm who just figure we'll send a new guy. And, but I just feel like it's actually part of the litigation. You know, it's another proceeding. And a lot of times these clients, when they're on their own, they get taken advantage of. Doctor will put something in there or grill them on the accident itself. And then you got liability problems now where you had the thing tight. So, but yeah, I agree. It's a problem if you ever have to dispute anything. You don't want to be the witness. So having somebody like Lisa or Tim there is pretty good idea.
your client alone and an examiner with a doc is at their mercy. I mean, and there's nothing that your client can really do about it. What you said too about confrontations, I've been at this so many years, and it's the same docs. And I believe this is because of me, because have intervened about the mechanism of injury. I now see that instead of asking, a lot of times they're pulling depositions out. They're reading the details out loud and maybe just say, that's the accident as I understand it. Okay, you can read that from the deposition. Great. The client didn't, where prior to, for leading up to that, I used to refer them to the deposition if they wanted, the details. So that my point is all Tim's in here again. I got to pull the deposition out where the client's by themselves or with somebody else. It might not happen.
Right.
Yeah, yeah. Okay, any other questions or comments? We're right at almost at our hour end time. Okay, I think that's it.
Thank you.
So Jen, you can stop recording, please.
Mhm.